Claimant gets to work and realizes he forgot his keys. On his way back home to get his keys, he gets into a car accident and injures himself. Claimant thinks the employer should pay his medical bills. Employer does not think they should pay for his medical bills. If only he remembered his keys at home, this wouldn't be an issue. But then I wouldn't be making this video. You need to watch this video because I'm gonna explain everything you need to know about car accidents in workers' compensation claims. Specifically when the claimant was either going to or coming from work. I'm gonna give you the 5 questions that you need to answer every single time you're dealing with this issue. Do not skip any part of this video because every single question is extremely important and you do not want to miss a single question. Quick disclaimer, this is not legal advice, every case is unique, and if you need legal assistance, reach out to an attorney. Like me, my name is Levi Graham Weinstein and this is the going and coming rule. We are looking at the going or coming rule. Basically, if an employee is on his way to work or coming home from work, an accident that he suffers is not covered by workers' compensation insurance. The employer shouldn't have to pay for it. Like I said, there are 5 questions that we need to answer in every going and coming situation. Question 1. Was the claimant going or coming? The rule applies if he was on his way to work or coming home from work. It's a basic question to answer, but it's something that is extremely important and it is the trigger of this rule. The next question we need to ask is about the vehicle. The statute asks whether the claimant was in exclusive personal use. What does that mean? Well, the courts actually recently talked about exclusive personal use. It doesn't matter if it's an employer-provided vehicle. In this case, Kelly Air Systems, there was an HVAC employee who was driving home from work in an HVAC car, and it was not found compensable. So it's not about who actually owns the vehicle. I'm going to read directly from this case. The question is not whether an employee can use the vehicle to take his family on vacation. The question is whether it is available for his exclusive personal use for travel to and from work. Meaning that question 2 is, was the claimant in exclusive personal use? Before we get to questions 3, 4, and 5, let's look at the case. Thomas Torok versus Momentum Solar. The following information comes from a final order that was filed on July 28th, 2023. The claimant worked as a solar panel marketer. The claimant sold solar. What that means is that he would go door to door selling solar panels to be placed on people's houses. He would drive his personal vehicle to the employer's location. At the employer's location, he would get into an employer-provided van that would take him to sell solar, where they would then harness the energy of the sun. The employer needed the claimant to have a cell phone. The employer did not provide the claimant with a cell phone or pay for the cell phone. It was the claimant's personal cell phone. These facts are very important and they come up later. The reason the employer needed the claimant to have a cell phone is because the employer required the claimant to download an app on his phone. The claimant could only do his job if he had his phone. The claimant needed the app to do his job. The claimant would input his sales into the app on his phone. This is a lot of facts and I'm gonna sum it up for you really simply. The claimant drove to work. At work, he realized he did not have his cell phone charger. He asked his boss if he could go back home to get his cell phone charger. His boss allowed him to go home, although his boss told him that when he came back, he would either be tardy or if he missed the employer-provided vehicle, he would be absent. The claimant went home, grabbed his charger, and on his way back to work, he was involved in a motor vehicle accident. Let's stop right here for a minute. Let's answer question number 1. Was he going to or coming from work? Yes, he was. He was on his way to work. Let's answer question number 2. Was he in exclusive personal use of the vehicle? Yes, the claimant was in exclusive personal use of the vehicle. It was his personal car. This wasn't an employer-provided van. He was still in his own car.
It's also important to note that the employer did not place any restrictions on what the claimant could do with his own car. The claimant could have done anything with his car. He had exclusive personal use.
So this actually leads right into questions 3 and 4. This is what the judge said. In the statute, there's an exception called the special errand or mission rule. It literally says it right here. Unless the employee was engaged in a special errand or mission for the employer. Going back to what the judge said, courts look at 3 factors when ruling on special errand or mission. The difficulty of the task, how different the task was to the employee's usual duties, And how far out of the employee's way does the employee have to go? And this leads us to question 3. Question 3. Did the employer ask the claimant to do something special? If you work as, I don't know, say an insurance adjuster, and your duties involve waking up, going to your work from home desk, and adjusting claims. If you get an email from your supervisor that says something like, I'm really proud of this example. If you get an email from your supervisor that says, I bought the staff new computers, please pick up the computers and deliver them to the staff that lives within 100 miles of you, that would probably be a special errand or mission. The judge continues his analysis to what will be our question 4. The judge talks about the dual purpose doctrine. If the trip has both a personal and a business purpose, it falls within the dual purpose doctrine exception to the going or coming rule. Now, there's a lot of factors to this, but I'm going to show you the main one. Swartz was a seminal case in the going and coming rule. It's an extremely long case, and if you want to read it, go for it. I did, and it's honestly a very interesting case. The long and the short of it is this. The dual purpose doctrine has a lot to do with transportation of items. If you are taking items that are necessary for the business to succeed from one place to another, it may fall within the dual purpose doctrine. There's a ton of analysis, and it's honestly not the easiest thing to prove. In Swartz, she was transporting an entire booth that was going to be used at a convention for her company. I'm not going to get into all the factors, but it really has a lot to do with how necessary the items are for the business to thrive. Which leads us to question 4. Did the employer ask the claimant to transport items? In our case today, the item that the claimant was transferring, I guess you can say was his cell phone, and on that item was an app that I guess he was like transporting to the business. The judge uses what I personally find to be the greatest legal doctrine ever. I guess it's not technically a legal doctrine, but I'm just going to call it a legal doctrine. The forgetful claimant doctrine. I'm calling it the doctrine. I'm going to read exactly what the judge wrote. I find that the line of cases referred to as the forgetful claimant are applicable to the facts of this claim. The forgetful claimant cases involve accidents that occur on trips to or from work necessitated to retrieve some forgotten item that was usually left at the injured worker's private residence. In Everett, the claimant forgot her key at home. In Watkins, the claimant accidentally took the business's keys home. In Rodriguez, the claimant locked his keys in his car and had to drive the company's vehicle home. A lot of keys cases with these forgetful claimants. And if you're an adjuster and you want to unlock the key to some very high quality defense litigation, shoot me an email. That's a major key. Ultimately, the judge ruled that this accident was not compensable. The claimant forgot his phone charger at home, and he wouldn't have had to make that second trip had he not forgotten it at home. The employer didn't ask him to go home. He drove home in his personal vehicle. Maybe if he remembered to charge his phone the night before, this wouldn't have happened. And that's the going and coming rule. Or is it? That is the end of the case, but that is not the end of the going and coming rule. We have not gotten to question 5 yet. So we're not going to talk about deviation from employment. That's for another video. Question 5 has to do with traveling employees. Under the traveling employee exception, if you were working while you were driving, the accident is compensable. Now, this exception clearly indicates that it does not include travel to and from work, or as we know it, the going and coming rule. But what if the employee was working while he was on his way home? Question 5 is, was the claimant earning wages while driving home? Or driving to work, you get it. The seminal case here is Nico Gold Coast Cruises. It's a 1984 case. This case was actually published before the going and coming rule even existed, but it laid down a lot of precedent. I'm not going to get too into the facts, but the short and sweet of it is this. The claimant was a cashier. At the end of the night, he would take all the profits and bring them to his personal home where he would lock them in a safe. Although he drove his own vehicle, the employer paid him extra money to do this service. It was also an essential part of their business that their money stay safe, meaning that that ride home was part of his job. So his accident was compensable. Overall, the going and coming rule says that if you are in a motor vehicle accident when you are driving to or driving from work, that accident is not compensable. There are lots of exceptions, and there are 5 questions that you need to answer. My name is Levi Graham Weinstein, and if you need the greatest workers' compensation defense attorney, email me. My email is in the description.